finished it, and
Okay.
how much more time do you still need?
My Lord, now I will simply invite your Lordship to make reference to the rest of our submissions as highlighted, my Lord. But, my Lord, just allow me 10 to 15 minutes to make direct responses to what the defense submitted.
First, make a summary of.
Most obliged.
Nti oludda lw'omuwaabi lwalulemereddwa okuleeta obujulizi nti yali alina obulwadde bw'obwongo, nti kubanga bw'agamba nti yali alina obulwadde bw'obwongo balina okulaga nti mu butuufu yali tamanyi kyakola, yali yeeyisa ng'omwana omuto. Ti buli muntu omutwe gwe teguteredde, naye omuntu bw'avaayo n'agamba nti omutwe gwe tegukola bulungi, alina okuba nga tategeera ddala kyakola. Okugamba nti omutwe gwe gwali tegukola tekimala okugamba nti yali mwenyamivu wakati wa January n'omwezi ogwokusatu, nti ate ebyo byaviira kubeera n'obulwadde bwa nalubiri oba sickle cells, nti bwe baamukwata n'agamba omujulizi w'okumu nga ye yamukebera n'amugamba bye yamugamba, naye teyabikkiriza olw'ensonga nti omusawo omulala yali tabikebedde okukakasa nti byali bituufu, nti era baamukebera oluvannyuma lw'ennaku 5 nga bino bituuseewo, era ne basanga nti omutwe gwe gwali gukola bulungi. Nti okuggyako omujulizi ow'okumu waliwo omujulizi w'okumu na babiri, nti era yamukeberako mabega nga omwami Okello yali yeetutteyo mu ddwaliro, nti emyezi 3 kino kiryoke kibeewo, n'asanga ng'omutwe gwe gwali gukola bulungi. Nti era n'agamba Oweekitiibwa Omulamuzi nti atunuulire obujulizi bw'omujulizi w'okumu nti kubanga yamugamba nti yali amanye ensonga lwaki yatta abaana. Oludda lw'omuwaabi lwalugamba nti yali takoze statement, naye oludda oluwaabi lugamba nti omuntu ne bw'aba talina statement kasita ajja mu kooti n'awa obujulizi ng'alayidde, kooti bw'erina okutwala. Nti balemereddwa okulaga nti yali tategeera kiki kye yali akola oba kyali kizitowa kitya, era ne bye yayogera ng'agamba omujulizi wa 15 ng'amugamba ne bye yayogera ng'agamba omujulizi wa 15 kyali kiraga nti yali ategeera biki bye yali akoze. Nti olw'ensonga nti tebasobola okuleeta obujulizi okulaga nti bye yakola byali bikyamu, nti yali amanyi bye yali akola kubanga bwe baamubuuza nga bamaze okumukwata yagamba nti yali amanyi nti ebintu bye yali akoze byali bisobola okumutwala mu kkomera oba okumuviirako okufa, ekitegeeza yali amanyi biki bye yali akola nti byali bikyamu.
Yes, Mr. Morgan, you can proceed.
My Lord, very first, in our response to the allegations of insanity as brought out by Counsel Kumbuga, my Lord, the claims of insanity as submitted, my Lord, are not borne out of evidence. They are allegations being made by counsel at the stage of submissions. For lack of a better word, my Lord, and with the greatest respect, it is evidence from the bar. My Lord, as to the allegations that the accused was such that was mad to the extent, my Lord, if we understood him the extent of living on the streets, that there was evidence that accused was living on the street, and that this is attributed to his mental inabilities. My Lord, again, this is not evidence from the accused. He did not qualify the reasons for his going on the street as being mental illness. To the contrary, my Lord, the evidence from DW3, 3, demonstrates the accused as a philanthropist, gathering and providing for street children. There is no evidence to show, my Lord, that he was on the street, that he went on the street where he found DW3 as a person of mental incapacity. In fact, my Lord, evidence of DW3 is that the accused was actually paying and sponsoring the welfare of street children. I do not think, my Lord, that a person with mental instability can carry out such acts of philanthropy. My Lord, the defense has submitted that because the accused was got with some painkillers, that is evidence of mental illness. My Lord, painkillers are drugs in common usage. In fact, the accused did not tell this court what he was doing with those painkillers. It is, in our opinion, my Lord, improper to conclude that whoever carries or uses painkillers is a person with mental illness. My Lord, as to the references to PW11, PW11 is evidence that even people with mental illness can transact etc. My Lord, the witness was clear that they can only do such normal businesses during the time when they are normal. Indeed, my Lord, you can see that just minutes prior to the killing of the children, just within minutes, the accused, from the exhibits on record, my Lord, was downloading money from his bank account to his phone and transacting in mobile money from his phone to the phone of the caretaker. That can only be done by a person who is normal. My Lord, on the aspect of the alleged episodes between No, my Lord, not episodes. My Lord, not episodes. As to the assertion, my Lord, that that prosecution did not bring any evidence to show that between the 1st and the 7th of April, the accused was normal. We have already highlighted, my Lord, that that burden rests on the defense and not the other way around. My Lord, there is no evidence that the accused was denied the citizenship of Uganda at all, or if so, that denial was on account of mental illness. My Lord, the allegation is that because the accused is said to have made some laughters during the proceedings, these proceedings, and therefore that is evidence of mental illness. My Lord, there is no such standard. That laughing alone is a standard to determine a person's mental capacity. The accused was not asked why he was laughing. It cannot be assumed. My Lord, I've already addressed the note on Police Form 3. Police Form 24. My Lord, the criticism that or against PW made against PW 15 that he concealed information of the accused is accused having been in Butabika mental hospital. And that this unrevealed information by prosecution should be used as evidence of to prove mental illness, my Lord. My Lord, that is not the legal requirement. What we have on record is that the witness was asked and he says he is aware of that information. And my Lord, the information was abundant on record. in Police Form 24. This witness was never asked by the defense, my lord, whether he verified that information. Because this was information from the accused. My lord, the defense made a case for what they termed criminal negligence, the absence of a guard at the center, absence of a visitor's book, my lord, this court is trying murder. It is not the school management on trial. It is the person that took advantage of the circumstances to commit the crimes that is on trial. In any case, my lord, the absence of a permanent guard or a visitor's book can never be a defense to murder. To the contrary, my lord, a person who commits murder, a person who commits murder due to absence of security or other preventive measures can only be said to have done so consciously. My lord, that a witness called Mpamizo did investigations and produced exhibits in the middle of the trial. We respond that, my lord, the all exhibits of Mr. Mpamizo were disclosed to the defense. The defense never objected to his testimony. They even never expressed their inability to deal with that evidence for whatever reason. They properly cross-examined the witness. And so, my lord, the late service of Mr. Mpamizo's evidence never occasioned any miscarriage of justice. My lord, as for Mr. Angulo, prosecution witness number 18, in regard to the court order, my lord, we submit that the witness was clear that he was only concerned with the court order as opposed to the underlying processes. My Lord, we draw your attention to the loan affidavits Section 4 of the Commissioner for Oath Act allows any magistrate, by virtue of their official powers, to commission oath. In fact, it talks about magistrates, registrars, etc. My Lord, there is no law that invalidates an affidavit that is commissioned by a magistrate who proceeds to hear the same matter. My Lord, that conflict only arises in respect of counsel, advocates, not judicial officers. And my Lord, that is the position in Section 5 of the Commissioner for Oath Act, which restricts that type of conflict to advocates and not magistrates. In fact, my Lord, to fault a magistrate who commissions an affidavit in an application before themselves, my Lord, would be also to fault the powers of this court that administers oath of the witness and proceeds to hear the same witness in evidence. The courts are not restricted in law. My Lord, the absence of a court seal on a court document does not in any way invalidate the force of law in that document. My Lord, reference is made to Section 221 of the MCA, which speaks to that effect. Absence of a seal doesn't affect the validity of a court order. There is a presumption that every court order, my Lord, is authentic, enforceable, and legal, unless it is overturned. Now, on the issue, my Lord, just rushing through. My Lord, on the issue of PW 7, of the recording office of PW 7 not signing the plain statement, the witness statement of the witness, my Lord, I pray that you still make reference to the principle in Uganda versus Augustine Musana, cited. My Lord, on the submissions on the case of Kantinti, Uganda versus Kantinti, we understood the defense to say that because court found Kantinti insane in that matter, for the reasons they state, and it should apply here. My Lord, in Canteen, the facts in Canteen are distinguishable with the present case before you. In Canteen, the accused person produced cogent evidence of his mental illness, including medical evidence, including photographs of his state before the commission of the offense. And so the court rightly found him so. My Lord, that is not the case in this case. We have been criticized, my Lord, for not having called Semanda, because Semanda is the investigating officer. My Lord, there are three things. One, a criminal case like this, my Lord, is not investigated by a sole investigating officer. In this case, my Lord, prosecution produced PW 14 and 15, who are all technically investigating officers in this matter. My Lord, the police form 17s were all tendered and admitted in evidence. My Lord, once an exhibit is admitted, Section 133 of the Evidence Act does not put a limit as to which number of witnesses should be called to prove a fact in issue. Secondly, the decision, my Lord, in the case of Alfred Bumbo, my Lord, B-O-M-B-O, and three others versus Uganda. My Lord, this is a Supreme Court Criminal Appeal number 28 of 1994. It's available on ULI. The Supreme Court, my Lord, in this case held that whereas it is desirable that evidence of the investigating officer and or a rearresting officer should always be given where necessary, we think that where other evidence is available and proves the prosecution's case to the required standard, the absence of such evidence would not, as a rule, be fatal to the conviction of an accused person. And my Lord, the Supreme Court went on to say that it depends on the circumstances of each case. So the defense, my Lord, cannot be right to criticize the prosecution for not having called every other possible witness in the matter. My Lord, finally, on the issue, my Lord, that the police form 17s, police form 17s and other exhibits which should have been spoken about by Semanda, who was not called, just redundant on record, or something like that. My Lord, the law has always been clear. My Lord, we shall provide this authority. It's a case of Johnny, as in John Y, John, then Y, Johnny versus James. Is 2006 in bracket 3 KLT 368. My Lord, this is a persuasive authority from the High Court of India, but it's of great relevance, my Lord, in addressing this issue. That court, my Lord, held that when the court receives a document and assigns, when a court receives documents, it's in plural, documents, and assigns numbers to them, it must clearly be assumed, that the